Very well. Good morning, everyone.
Good morning.
I'm pleased to be the very first one in welcoming you here after the introductory remarks from both the National Taxpayer Advocate, Ms. Nina Olson, and the Dean of University of Minnesota. And I'm thrilled of sharing with you and this very interesting and diverse panel a very few remarks on what the status on the taxpayers' rights charters and bills of rights and the effect of such charters and such bills of rights have in the practical protection of taxpayers' rights. We need to focus first in this panel in what the status of these taxpayers' bills of rights are. And as a teaser of what is to come tomorrow morning at the presentation of the IBFD Observatory on the Protection of Taxpayers' Rights, we can see that drawn out of the data provided by 67 reporters of 42 countries worldwide, 67 reports, from 95 reporters, we have that when asked, is there a taxpayer charter, a taxpayer bills of rights in your country, we find that 60% of those reports do acknowledge that those systems do have a taxpayer's bill of rights. But when faced with the following question, are these provisions legally effective, we find that only the 33% of those charters and bills of rights do have some kind of legal enforcement. And that draws us and that leads us to the analysis that it's the one that our panelists will be conducting this morning of how are these taxpayers' bills of rights to be integrated into the legal system? How are they going to work in the current environment of the relationship between taxpayers and tax administrations? How could they enhance not only the relationship between the parties of the tax relationship, but also the general efficiency of tax systems? And in this regard, we have divided this panel into, I'd say, two sections. The very first one will focus on the rationality of particular sets of rights that need to be integrated into these taxpayers' bills of rights, and how do they operate from both teleological and systematic perspective into the tax systems. That's the analysis. Stepan Gadjo and Sime Josipovic, I hope I pronounced it correctly. Well, fair enough. We'll be conducting along with Ms. Shelley Griffiths from taking the perspective of New Zealand. Then taking that analysis into an institutional analysis on how the taxpayers' bills of rights affect and how the infrastructure that needs to be put in order to further advance the practical implementation of these taxpayers' bills of rights. How is it to be put in order? It's the following part of our panel that will be conducted by Rodelio Dassil and Norberto Villanueva, as well as by Leslie Book. Without further ado, because I'm just the moderator, I'm not the star. The stars of this morning are my very talented and expert panelists. I would like to give the floor to Stepan Gadjo and Sime Josipovic, that will be introducing their remarks on the right to equality.
What's yours? Mine is there. Where's the pointer? This? Yeah. Well, thank you very much. It's really an honor to be the first speaker of the day and to get this all going today. I'm honored that I get the chance to talk today about equality in tax law equality and taxpayer rights. And me and Stjepan, we are both from Europe, so we are looking at a European context of equality. We'll start today with tax law and equality in general. After that, we'll look at the foundations of justification and proportionality in the equality test. This is important as this phase of the test is actually the core, the main area of dispute when it comes to equality. After that, we'll look at the practice of the European Court of Human Rights. And after that, we'll look at some European constitutional courts' common traditions or standards and why we have difficulties to identify them. But let's start. Equality. Equality as a concept in Europe exists for over 2,000 years. For 2.5 millennia in Europe, we know about the concept of equality. And that not in just a generic way. We also have identified the general principle that to this day exists in one form or another. Not just that equal situations, similar situations have to be treated equally, but also that significantly different situations have to be treated in accordance to those differences. So if we already know for so long how to define this criteria, what's the problem with equality? Well, the problem with equality is that the principle of equality doesn't exist for itself. It has, in a modern constitutional democracy, to be viewed in line with the principle of democracy itself. In a democratic society, we, as the people, elect the sovereign, the government, to enact laws, to enact policies, to put policies into place that are in line with what the majority of the people votes for. What's the problem with that? Well, we always have a minority. And the majority could always overrule the minority. And especially because of that reason, it's so important to protect minorities, to protect those that have not chosen the sovereign itself. And in this situation, we basically have a conflict on one side. Every law, every action of the sovereign creates classifications. It makes differences between different categories. Who gets, for example, a tax benefit, who doesn't get a tax benefit? Who gets an exemption, who doesn't? Which tax rate is applicable? How much do you have to earn to be in a certain tax bracket, and so on? Those are all categories that make differences amongst people. And they are necessary to enact policy. On the other side, when this goes too far, it can happen that certain categories are in danger to be excluded from society, excluded from the democratic process. So we need a balance between democracy and equality. Just if we have such a balance, both of those concepts can function. And here we come to the problem. How to solve this? Well, the constitutional legislators of Europe have created two principles, the equality principle and the non-discrimination principle. To be really simple about this, the equality principle forbids unequal treatment in general. However, because, as I said, the legislator needs some room to act, the legislator gets a broad margin of appreciation to decide what is and what isn't adequate treatment, equal treatment. With non-discrimination, we have put in place other standards. We have said that certain criteria cannot be the basis of a differentiation and should not be considered as those, except if there are really good reasons for doing so. For example, race, sex, age, social status, and so on should not be the criteria to create distinctions between certain groups. So, we have those two categories, those two criteria, which are often included in the constitutions of European countries and countries around the world. Furthermore, we have to consider that the legislator by himself needs a broader margin of appreciation because the legislator creates general rules. The legislator creates laws applicable to all people. The more specific we go, special rules in comparison to general rules, the more the legislator has a chance to take special circumstances into account. This goes all beyond the legislator itself to the public administration, to the tax authorities in our case, where tax authorities act on a case-by-case basis and, of course, are better suitable to consider special circumstances. For a legislator, it can happen that in certain situations, general rules will affect certain groups more and certain groups less. For the tax administrations and administrations in general, this should not happen because they can take into account the circumstances of a case. What do we have then? We have basically the test itself. On one side, we have the infringement of certain rights. On the other side, we have the need for the legislator to enact policy and the reasoning behind those policies. And if we look at the classical scheme, those are weighted one against each other. However, what we say is that we also have to look into the general area, the general surrounding of this test, and that we have to consider, based on the democratic process and the differences between democracy and equality, the level of protection of an affected group, the level of certainty of targeting, and the source of inequality. What does that mean? We have to differentiate between general equality and anti-discrimination. We furthermore have to differentiate if a group is targeted proportionally, disproportionately, if it's certainly but indirectly targeted, or if it's directly named. And the further we go on these lines, the further we go away from the center, the more intense the infringement itself becomes, regardless of the intensity in a particular case. And the same goes for the source. It's much harder to discuss if a constitutional value infringes on equality than if it's an exemption or even an administrative decision. Well, we took this scheme and tried to put into it impairment versus justification to look at particular cases and see how they play out within this context. And just for our non-European friends here, before we go into special case law, the scheme of the human rights protection in Europe. On one side, we have the European Union, and on the other side, we have the Council of Europe. The Council of Europe is much broader and includes most of the European states, including also the European Union itself. And this creates a three-level protection of human rights in Europe. The Council of Europe, or the which has the European Court of Human Rights, the European Union, and individual states. And on all three levels, human rights are protected. The principle of equality is in one way or another protected, also in tax matters. Now, we have differences that, for example, the European Union is limited in certain aspects in tax law, but all levels play an important role in considering how well a right is protected. And let's now go to the practice of the EC, European Court of Human Rights. I don't want to go into detail because we don't have time for this, but really simply, the European Court of Human Rights rules based on Article 14 and other material rights if a human right is violated. First, we have to look if discrimination appeared. Then we have to look if this discrimination violates a certain human right. And the third thing is we have to look if there's if this special treatment is reasonable and proportionate. So basically, this is the test we have. And here you can see the definition of Article 14. You have special categories that are protected, and you have, in the end, this or other status. What does this mean? This means that the protection of the Court of Human Rights starts basically slightly before anti-discrimination, as it includes other status itself. And today I brought you an example of a case of such an other status, the Guberina case. The Guberina case was actually a Croatian case where we had Mr. Guberina, a man who had 3 children, and he owned a flat in Zagreb. And this flat was on the 3rd floor without an elevator. And Mr. Guberina's 3rd son was born with heavy disabilities and couldn't walk up those stairs. So as his son was growing, he couldn't carry him anymore, and he had to buy a new flat. Now the question arose, not to go into detail, if Mr. Guberina could take a tax exemption based on the fact that he didn't have already a property to live in. So what happened? The court basically saw that the general rule said that everyone who had an apartment that didn't have all the necessary amenities to live in would be allowed to get the tax exemption, but didn't consider an elevator to be such a fact. In conclusion, the court said to this that this is unacceptable because we had an indirect but certain impact on those categories. And Mr. Groberina was certainly affected, even though not directly named. Furthermore, the court, I'll skip this, said that the administration could have acted here and considered this criteria. However, the Croatian government said that the administration acted righteously here because they acted how the law was intended. So we basically had infringement based on a statute with an indirect but certain impact, and we had semi-protected criteria. And the court said, considering all those facts, we have an infringement of human rights, the right to equality in this case. And this standard is the current strongest standard of inequality protection based on the European Court of Human Rights. There are other cases like Darby that I don't want to go into, but this standard is currently the status quo. If this would apply, if the impact wasn't 100%, we cannot tell right now. But what's the problem? The problem is that the decisions of the court just apply to semi-protected criteria, so that we just from this starting point can look at the court to get a common concept of what is protected. And for everything else, we have to look more into national law or European law. And I don't want to go into detail to not take too much time from my friend Stjepan, but basically we have the problem that constitutional rules can change how this matrix should be looked at. For example, Germany has a specific clause that forbids affirmative action, while, for example, Switzerland says that affirmative action steps have to be taken in certain cases. And this can change the whole structure, and we want to take this structure now into account and to look into specific cases how this can apply. And Stjepan, I would invite you to finish this presentation. Thank you.
Thank you. I will skip directly to the conclusions since the moderator has given me a sign of 3 minutes. So my role here is severely limited in that I will wrap things up by offering some general conclusions on our topic. First of all, our goal was sort of to identify some common standard of protection of taxpayers' rights when it comes to equality and non-discrimination inside Europe. This is really a complex assignment. Why? Because in Europe we live in the area of what we usually call constitutional pluralism, in that you have multiple levels of protection of certain rights. Šime already mentioned the influence of the European Convention on Human Rights. You have national constitutions, and you cannot skip the role of EU law, especially for those countries which are member states of the Union. And in the EU law, especially after the Lisbon Treaty was adopted, you have a new architecture of human rights protection. So basically, similar concepts arise in all of these three levels. Sometimes they overlap, but sometimes you have a similar concept but different conceptions of the concept. And this is, we didn't have the time to go into all the details here, but I believe that the model that Šime talked about before offers a nice way of thinking about the fundamental problem of the margin of appreciation that the legislator has when imposing certain measures which may affect the right to equality or the right to non-discrimination. As you can see, there are different conceptions on national level in Europe. For example, in Germany, you have strong judicial activism when it comes to protection of fundamental rights, meaning that the state has a lower margin of appreciation in these matters. In some other countries, like for example Netherlands, the margin of appreciation is wider. Of course, on the other hand, you have the European Convention on Human Rights, which is basically the minimum standard for all European states. So the practice of the European Court on Human Rights offers a chance for, let's say, a crystallization of these minimum standards. In the future, and this is what is mentioned here on the last slide, the future will probably offer a chance for not only the European Court on Human Rights in Strasbourg, but also for European Court of Justice in Luxembourg to go further, to offer further crystallization of minimum standards when it comes to equality and non-discrimination in Europe, in sort of interjudicial dialogue. In this respect, and this is my conclusive remark, I believe there is a specific role for the ability to pay concept, which arises on multiple levels in Europe, which is in some countries in Europe a basic constitutional standard. It is the basic constitutional right in certain European countries. In some other countries, it is also used in assessing tax laws. And just to conclude, ability to pay was also addressed in a number of decisions also by the European Court of Justice in its jurisprudence about fundamental freedoms. So probably in the future we will get the answer whether ability to pay is actually has some role to play in identifying the minimum standard. So thank you very much for your attention.
Now Leslie Book will address the audience regarding the right to receive advice from the tax authorities.
Thank you so much, and thanks Nina and Kristen and everyone who's put in so much hard work to make this conference come together. It seems it's seamless, but I know there's a lot that has gone on behind the scenes, and it's really an honor to be here and talk to you today briefly about taxpayer rights from a U.S. perspective, with a twist, and thinking about it from, in particular, how some of insights from self-help and design insights, design principles that have arisen outside the tax context can help operationalize taxpayer rights. So what I'm going to do today in this brief time is to give a brief update on the status of taxpayer rights litigation in the U.S. and go through where we are in the few years since there's been administrative adoption and codification. Talk briefly about the context in which taxpayers, mostly low income, but not exclusively low income, because taxpayer rights is an issue that encompasses not just underrepresented taxpayers, but talk about the context in which it's difficult for taxpayers at times to understand their rights and responsibilities as taxpayers. And then finally, I'll pivot to sharing some insights from the legal design movement and offer some applications into a particularized area in which there could be some application for U.S. taxpayers looking at a technical issue, cancellation of debt income. So with that, let me, and I should mention, all these things, those three things could take up a separate panel. I'm going to be talking sort of at a higher level just to give the big points or the main points on those topics. And there will be a paper coming out of this with my colleague Keith Fogg, who was supposed to be here, but on his sabbatical, rather than spending time working at my sabbatical, I'm a professor in residence with Nina Taxpayer Advocate Service. My colleague Keith is biking across the country, each of which has high points and challenges. So Keith is sorry to not be here, but he is somewhere in the southeast of the U.S. making his way across. So where do we stand in the U.S. on taxpayer rights? As many of you know, there was an administrative adoption of taxpayer rights in 2014, followed shortly thereafter by codification in 2015 in Section 7803 of the Internal Revenue Code, which provides that in part of the description of the commissioner's duties, that the Commissioner of the Internal Revenue Service is to ensure that employees essentially are familiar with and act consistently in accord with taxpayer rights. So as the panel was teed up, one of the main issues across the world is what are the remedies, or are there remedies for alleged violations of taxpayer rights? And not surprisingly, in the US, which is a pretty litigious society, shortly thereafter, after codification, there have been some cases that have been testing this. And the taxpayers are extraordinarily different in in where they come from. Facebook, as we know, is a large, very well represented company with many resources. And the taxpayer, Mrs. Moya, in the second case was an unrepresented teacher who had a case in tax court. And without getting into the details of both the cases, the main issue in both cases revolved around whether alleged violations of a taxpayer right resulted in a remedy that a court could affirmatively impose. And in both cases, the court concluded that the alleged violation of taxpayer right, in Facebook's case, the right to appeal, and in Moya's case, general concerns about the conduct of an examination, including the taxpayer who had moved from Nevada to California, claimed that the examination should have been centered around where she lived. The district court and the tax court in both cases concluded that the violations or alleged violations did not essentially produce a separate remedy. It's not the last word in these cases. I suspect that in future conferences, we'll see cases teed up in other areas, especially perhaps collection cases, where there's a different role that courts play in considering taxpayer rights or considering the agency's actions in accord with its procedural obligations. So I suspect we'll see more. But for now, that's where we stand. And now, as a lawyer, as a U.S. lawyer, oftentimes think about taxpayer rights or issues in the context of specific legal remedies. However, I think one of the things that I've tried to do is consider how rights can arise in different contexts outside specific legal disputes. And in part, I give credit to Alice Abreu and her colleague Richard Greenstein who had a symposium last fall where they brought together scholars and practitioners to consider thinking about taxpayer rights from many angles. So one of the areas in which which one can think about taxpayer rights is the way in which the administrative agency communicates with taxpayers. And there are many, many notices that the IRS sends. A number of notices have particular impact among lower income taxpayers, but not just low income taxpayers. And there is, I think, suffice to say, room for improvement in many of the notices that the IRS issues. And there have been significant recommendations and studies surrounding those notices. And there are there's a recent report in 2018 annual report that looks to looking from insights from other areas, behavioral science and psychology, and thinking about ways in which the agency, the IRS, and other agencies can perhaps improve the way they communicate with taxpayers. I think that's very helpful to think about ways in which taxpayers can be informed, but also act upon the rights which are generally available to taxpayers, even if they don't generate a specific remedy when there's a violation. So one of the things that I think is somewhat unique, although not only in the United States, is that taxpayers do have access to sources to help to legal representation. Obviously, if you're well resourced, you can pay. You can pay for representation. But even for those who are not, the U.S. system has since 1998, a system of federally supported or federally funded low-income taxpayer clinics, which are widely dispersed throughout the country. They're not everywhere, but I think they're now in 48 states. They provide an opportunity for people who might be struggling to understand their rights with the IRS to get assistance, and I think that is and the most recent report from that submitted annually that summarizes the tax clinics and their impact shows just how important they are in our tax system and representing many thousands of taxpayers, making a significant difference in the lives of taxpayers who people who, but for representation, might have struggled to get to the outcome which they may be entitled to, or to understand why the IRS actions which were taken were perhaps appropriate, and why there may be a liability which is owed. There are many other sources for information that taxpayers can look to, including the IRS, the website. There's an interactive tax assistant. There are telephone lines, taxpayer assistance centers. There's a lot that one could talk about concerning the level of service and telephones. There's been a lot. There's certainly areas for improvement in all of those. I'll focus briefly on taxpayer assistance centers, which are walk-in sites where taxpayers can get help. And there has been there was just a report recently that Treasury Inspector General released that discussed the shortcomings in access to taxpayer assistance, and it's among communities where there are low-income taxpayers and among communities that are receiving IRS notices. Very interesting, and it shows that there are challenges and opportunities for improvement. One of the things that kind of inspired me to think about struggle for information is in, I guess, one of my side hustles, is I started or co-founded a blog called Procedurally Taxing. And in that we started it with about 5 years ago, and there's a very small universe of people really interested in tax procedure and tax administration, and many of those people were in this room today. We thought that this would be a tool that would be used principally by other practitioners and academics with an interest in this area. But in fact, the site has generated, now we're over 1 million views. Many of our hits are from taxpayers struggling to get information. And in fact, our single most popular post was a post that was written a few years ago that looks at the ways in which taxpayers can get information to avoid having a refund offset against another tax liability. There are, I looked at this last night, there are over 120 comments that taxpayers have made, and I get emails from taxpayers asking for assistance all the time, and it's heartbreaking, because a lot of these taxpayers are depending upon their refunds to meet basic needs, and they're struggling to ensure they get what they've expected to receive. I could talk more about the offset bypass refund process, but again, that's for another day. Now, what this has taken me to is to think about, well, what can we learn in the tax system from other disciplines? And there is a rich literature that looks at access to justice generally in civil matters, not tax. There's a rich research body of research looking at the ways in which design principles can improve essentially outcomes for people who are generally facing financial distress and who are generally unable to obtain or to have representation, full-on representation. So there is a fascinating study that was principally authored by a colleague of my co-author in this paper, Keith Fogg, Jim Greiner, who is a professor at Harvard, who heads the Access to Justice Lab there, which studies the ways in which individuals, mostly in the United States, can improve outcomes through self-help materials that courts, clinics, and interested parties can generate to individuals who are caught in the legal system. One of the things that the article does, and some of the research highlights, is there are significant barriers to both action and understanding, which for many of us in this room have a hard time appreciating the challenges that individuals may face when interacting with a tax agency or with a court. Things like just anxiety that surrounds being swept into a legal process. Significant research around the impact that poverty and stress has on what is referred to as typically as reduced bandwidth to deal with problems. So individuals who are facing dire poverty or facing adverse circumstances have limited cognitive ability to handle and address problems which those of us in the room might have an easier time managing. There is just an unfamiliarity with some basics, things like, what does it mean to get a letter from the IRS? When I directed a tax clinic for 10 years, I had many taxpayers coming in to me and meeting with me and my students who were worried that a letter from the IRS meant that they were going to jail, right? And just the sense that they were in trouble and they were oftentimes close to panic. So there is, in addition to barriers to action, there are barriers to understanding. There's research shows that the way to get information across to many individuals includes things like use of analogies and visual images that can promote understanding and reduce some of the challenges that individuals face. So there are strategies that's and the research is now taking these strategies and using randomized controlled trial experiments, seeing what the output, what the take-up is, and using different ways to communicate. So some specific strategies which I think are helpful and could be useful in the tax system include things like cartoons, not suspecting or suggesting that the IRS inject cartoons in necessarily notice of deficiency, but perhaps in a way that others communicate, previewing content, advanced organizers. So here are just a few samples from again, this is not in the tax area, this is in the context of collection cases and eviction proceedings in New England. There are materials that basically provide general information about what the context is of a legal action. And this has been proved to be effective in allowing people to understand what is the process and what are the rights that they can exercise. So even simple strategies like calling out, highlighting things which are on formal correspondence that might be received from a state or an agency. There are, simple, again, cartoons to reduce the anxiety and the challenges of unfamiliarity, letting individuals know what to expect when they perhaps will walk into a court. It's, again, just knowing where to go to sit, things like that are challenging and can prevent people from understanding and exercising rights and exercising their rights. Previewing, letting individuals know what their rights are. Again, that is incumbent or in part of what the IRS has been trying to do with Publication 1, but there are, I think that can be reinforced by other actors who intersect with individuals. So, with the last minute of my talk, I just want to quickly spin this to the tax system. Well, how could this be applied to taxpayers so that they could perhaps fully exercise their rights? Well, Keith and I have been thinking about this in the context of cancellation of debt notices. So as I suspect in other tax jurisdictions, when a lender discharges a debt, there is income, gross income. There are exclusions for that apply for taxpayers who are insolvent or in bankruptcy at the time that there's a discharge. A lot of taxpayers are surprised that they may have gross income when there's a debt cancellation. A lot of times the cancellation arises because the individual is in financial distress. So this project that is applying these design principles in this context is trying to get information to individuals to show what, in fact, individuals can do to take advantage of the insolvency exception to cancellation of indebtedness income. So again, in the interest of time, I'll just show a few of the materials, but just letting individuals know that, in fact, there may be an information return was likely submitted both to the IRS and to taxpayers, and what does it look like? The form is 1099-C in IRS. Then the materials that are put together include sort of a preview, letting individuals know what's coming and understand, because it can be intimidating getting a stack of papers or information. Then there is a kind of a walkthrough in the analysis of liabilities and assets. And when I directed a tax clinic, one of the exercises I had my students do to help them prepare for working on collection cases was try to determine a taxpayer's collection potential based upon their assets and liabilities. motivated students, smart students, it's really difficult using the IRS materials to get to the same place. Even if there's a set script that I would give students a script, they would have a hard time navigating, trying to figure out what a taxpayer's financial circumstances are. That this project gives kind of cues and insights into how individuals can figure out what their liabilities are and what their assets are, right? Where else can you look for to see what assets might be? So I think this, in concluding, I think that the takeaway for me is that there are many opportunities to think about how we can inject taxpayer rights to improve tax administration. And there are many circumstances where individuals interact with the tax system, with the tax agency, with the court. We were hearing just the other day at an ABA meeting about the IRS and tax IRS pilot program with settlement days, with taxpayers coming into cases in tax court. The information that's presented to those taxpayers could really benefit from some of the insights from design, the literature around design principles. And I think that there are many opportunities for thinking about this and applying this in the tax system.
Without further ado, Rodelio da Silva and Norberto Villanueva will talk to us about the experience of implementing the National Taxpayers Advocate in the Philippines.
Good morning. In behalf of my co-author, Norberto Villanueva, I'm presenting our report. Introductory, our office is the permanent technical arm of the Senate Committee on Ways and Means, which assists our senators and congressmen on tax matters. And I have been in the legislatures since 1987, so I've been working in our Senate for the last 31 years. So my topic is how to institutionalize the taxpayers' Bill of Rights. An eminent professor said, taxpayer rights are human rights. It was said by our professor, Nina Olson, way back in 2013. And I'm happy to see my old classmates, Laura and Isabella, in Harvard Kennedy School, when our professor taught us about taxpayer rights. Thank you, ma'am, for imparting that knowledge to us. Our country is composed of 107 million Filipinos. We are the 13th most populated country in the world. However, we have only around 32 million registered taxpayers. 19 of them are individual, only 932,000 corporate, and others are one-time payers, or what we call those paying estate tax, one-time amnesty tax, or others. This is the breakdown of our taxpayers, or 1/3 of our population. But our tax efficiency, or our collection, is not quite high. It ranges from based on the percentage of the gross domestic product. It's only about 15.6 on an average of 14%, but I think the ideal ratios are between 17% or 18%. What I'm discussing this because this pertains to the trust and confidence of the taxpayers to our revenue agency. But for the last year, our tax effort has been gaining grounds because of our new president, Rodrigo Duterte. Then, the taxpayer rights is contained, among others, in various statutes, particularly in the Constitution. But our Constitution set a tax powering limitation upon the state in order to pursue equity and fairness and provide reliefs or remedies to our taxpayers. Based on our study and our research, our taxpayer rights are contained in the 1987 Philippine Constitution. Our tax code is contained in the National Internal Revenue or Republic Act 8424. The recently enacted Custom Modernization Act. If you heard it, our tax reform, which we passed 2017. And last year, we passed an ease of doing business, simplifying procedures in getting licenses business in the Philippines. For the last 10 years, our country is one of the countries who have a red tape, but with this new law, I guess we will make it easier to do business in our country. And finally, last year, we passed a tax amnesty to provide our taxpayer with a clean slate under the new administration of President Duterte. Like in other constitution of our countries, we believe that the rule of taxation shall be uniform and equitable, and we always pass a progressive system of taxation. And in the review of the tax laws, whether it is legal or illegal, the Supreme Court always the last court of resort in order to review whether the tax imposed is due or equitable. And finally, we have two provisions on due process, and no person shall be imprisoned for not paying of tax. As a simple summary, some part of our tax code or the revenue code, it provides a little bit of piece about taxpayer rights, particularly on remedies, on when to file, the days on how to file your assessment, payment, etc. And currently, our Bureau of Internal Revenue is intensifying its effort to be the forefront to make delivery of frontline services to our taxpayer easier, efficient, and to promote ease of doing business. Unlike before, we are now limiting the number of signatories. Years ago, if you file an income tax return, you need to secure at least 17 signatures of BIR officials, but now it's being reduced to only one and paperless transaction. When we review our taxpayer rights, it is contained in administrative rules under certain revenue regulations on the matters of abatement and cancellation of internal revenue tax liabilities, on compromise, on rules of assessment, and on how to proceed with if you receive a letter of notice and how to pay the same. But these things are only in administrative procedures. And we have a citizens charter as mandated by our national law that all government agencies in the Philippines should provide a citizens charter on how to transact with our revenue agencies or government agency, but only provides for certain steps. A reference and frontline, to have a level of playing field and what are the services being rendered. Our custom laws is antiquated. The last custom laws of our country was passed way back in 1978 under the regime of then President Marcos. But last 2016, we enacted and codified our custom and tariff laws in a called Custom Modernization and Tariff Act. Since the issue about taxpayer rights are being discussed in our country since 2013, we inserted two provisions in that Custom Modernization and Tariff Law. This particularly found now in Section 1132 of the CMTA to provide remedies for the taxpayer on the collection of duties, taxes, fines, surcharges, interest, and other charges. Before the passage of our Custom Modernization and Tariff Act, if you file an import permit, you need to secure at least 20 signatories. And it will take, again, 2 weeks to release your goods. But under the present system, lodgement is now in electronic form, and no signatory is needed, and goods now can be released within 2 days. As I told you, we revised our tax code in 2017 to make it simpler, the current tax system now, because our country is the highest income tax rates, imposing the highest income tax rate in ASEAN. We impose the income tax at around 32% as compared to our neighboring country, Singapore. It's only imposed around 18, or Hong Kong at 14, and other ASEAN countries at 20 and 25. We impose as high as 32. Our corporate tax is the highest in ASEAN at 30%. And our tax code is quite problematic, so that in 2017, we simplify the personal income tax. We simplify our estate and donors tax, making it now similar to the capital gains tax at 6%, but we expanded our value-added base. We adjusted our oil and automotive excise tax, and we are the second country, aside from Mexico, who are now imposing excise tax on sugar-sweetened beverages. But data on our train implementation, it provides hefty collection for our BIR. So if you read in the paper, because of the revenue collection that exceeded the target, our government now is in build program. So if you visit our country, our national bird is not eagle anymore, but crane, because of the various infrastructure. So this is the last latest law that to remove the red tape. We simplified the procedure: 3 working days for simple transaction, 7 working days for complex transaction, and only 20 working days for highly technical application. And there is now a mechanism to complain if the agency will not act on your request or the certain documents. And recently, in order to provide a clean slate, because there are around 20,000 pending delinquent cases involving our taxpayer, and if you, sorry to say, our state tax is not collecting so much. There are quite some properties being held under Spanish title, so we provide an amnesty for state and tax on delinquency in order to collect more and give our taxpayer a clean slate. And the statute particularly offers an opportunity to unclog the administrative and judicial dockets of slowing moving cases. All cases pending with our trial courts, Court of Tax Appeal, Supreme Court, as long it is not final and implementable, you can file for amnesty. As I told you, the issue of taxpayer rights come into force in our country way back in 2013, and it gained grounds. But like other countries, in order to pass a tax law, it should emanate from the House of Representatives. Unfortunately, when we introduced this scheme, I gave it to my Senator Recto, way back in 2013. But our Congress 2016 to 2019, my new chairman, Senator Sani Angara, who also earned his master's in Harvard, refiled this bill together, and it has now a counterpart in the House of Representatives. So we believe, because we just conducted our election last May 13, and our new Congress, to be called 18th Congress, will start roughly in June 30. We will reintroduce the same to our new senators, and we will codify the taxpayer's right in order to avail of information, prompt and accurate responses to questions for tax assistance, to simplify our procedure, to have a speedy and partial disposition of the case, to have a fair and consistent application of tax laws. In summary, how can we do that? We believe that if we pass at a codified taxpayers' right, it will increase our collection more, and we will reach the ideal target of 17 to 18% of tax revenue effort against GDP. We are planning to introduce more the taxpayer concept to our new senators and congressmen. On the part of my office, we shall recommend and motivate our new chairperson and members to assume critical role in passing this law, and to introduce the same. We will conduct a public hearing starting September, and I'm happy to note, together with Mr. Villanueva, we were authorized by our senators to be here in spite of the fact that we have only 9 remaining days for our sessions to pass various laws, because they wanted us to secure literature from the tax experts who are here. That's why we're calculating data in Asia Pacific, Europe, and US on jurisdiction, so that the Taxpayer Bill of Rights can gain grounds in the starting October 2019. And my office is authorized to conduct a tax forum twice a year. And I'm envisioned to, this will be my main topic way back in October 2019. And we intend to orient and educate the technical staff of the newly elected senators. And I came back to our country on Monday on what is this Taxpayer Bill of Rights. We believe that with new documents, and I saw the Purple Book of the National Tax Advocate Office, and I already read it early in the morning, that with new inputs, and I heard it from my friend in Croatia and from the tax expert from the University of Villanueva, and all those speakers this afternoon and tomorrow, we will gather more information and data, and this taxpayer rights can be passed by our 18th Congress. We said, during my time as the Director General of STSRO, we made bold moves by revising our tax code, because the last revision happened way back in 1997. We revised it in 2017. As I told you, our tariff law was antiquated. It was passed in 1978, but during my time, it was revised in 2016. With your help and other literature, I believe it can be done by the Philippines. Thank you very much.
Last, but definitely not least, Shelley Griffiths will lead us into an analysis of how a taxonomy of taxpayers' rights can be integrated into a system such as that of New Zealand, which is, as you well know, is of common law. How this lack of statutory provisions might help creating opportunities and challenges for taxpayers' rights to be properly implemented and secured.
Thank you. Tēnā koutou katoa. Good morning, and thank you to those who organised this conference, and in particular I'd like to thank Nina and Kristen for their invitation and for their warm hospitality since I've been here. So, talking about taxpayer rights in New Zealand, and at probably a level of abstraction rather higher than the previous speakers. As long as I've been interested in taxpayer rights, I've been flummoxed and somewhat troubled by the fact that taxpayer rights are treated differently in the discourse from questions about human rights. So while in New Zealand and elsewhere, the shape and the content of protections afforded to human rights instruments has been not bothered at all by the moral quality of the persons who have those rights. In the discourse around tax, the moral quality of those persons who intend or need their rights protected has been relevant. Why is that so? Is that appropriate, has been my question. So in New Zealand, we do not appear bothered by the fact that some of basic human rights are found to apply in the context of some pretty egregious persons and in some pretty egregious behaviour. Much of the New Zealand Bill of Rights Act jurisprudence has been around a person who at the age of 63 had spent 40 years of his adult life in prison for acts of violence and kidnapping. But we're not bothered by the quality of that when we come to think about his human rights. But when we come to think about the human rights of taxpayers, we are concerned about the moral quality and status of those persons. And so that led me to think about what is in fact being protected when we think about taxpayer rights. And that is part of what I want to talk about today. And I guess what I wanted to start by doing is summing up my two general points, and then I want to talk more specifically about New Zealand, a country that couldn't be more different from Philippines if you tried to imagine one, with 5 million people, not however many hundreds of millions of people. Anyway, my two general themes are this. However we conceive of taxpayer rights, the method of their recognition, if not their content, is a function of the constitutional framework of which they are a part. In New Zealand, written bills of rights are not what one might say natural. And the recognition of taxpayers in New Zealand is broadly consistent with the constitutional ecosystem that pertains there. My general conclusion about New Zealand, which is probably of very limited interest to you, is that we probably do need a person or an office to ensure such protection. And secondly, in thinking about this connection between taxpayer rights and human rights, and given what Nina said about what the theme is going to be in Pretoria next year, you probably think you've been time-travelled to October 2020. I've started to think about what it is that is being protected when we talk about taxpayer rights. And the way I'm thinking about it is that there are two categories. The first is what I call taxpayer as customer. By recognising the taxpayer's right to be treated well as a customer, we would assume that it is likely that taxpayers will comply with their obligations, that they will voluntarily submit to the system if they are treated nicely and well. This is, of course, a core technique of responsive regulation. And this has, I think, at its centre the tax system or taxation rather than the individual. And so that's what I characterise as taxpayer as customer rights. The other way I think of thinking about this is thinking about what I describe, for want of a better description, as taxpayer as citizen. These are the rights that spring from those rights that are grounded in the dignity of the human person, and the shape and make the relationship between the individual and its government. These are the rights affirmed in the International Covenant on Civil and Political Rights, which are the origins of many bills of rights in the post-World War II world. And in New Zealand's case, that instrument is specifically affirmed in the New Zealand Bill of Rights Act 1990. But in a system like New Zealand, which we will see a little bit more about in a moment, there are also rights grounded in the common law and in some underlying values inherent in the rule of law as we would conceive it, and with its origins in such obscure things as the Magna Carta. Some of these rights specifically relate to tax administration, such as, for example, the right to be secure against unreasonable search and seizure, the right to justice, or more specifically, the right to judicial review of decisions by public authorities. So what I want to do is, thinking about these two broad themes, is to talk to you a little bit about the recognition of taxpayer rights in New Zealand. And to do that, I need to talk a little bit about New Zealand. Now, to start with, in New Zealand, there is no Taxpayer Bill of Rights or similar instrument. There's no advocate or tax ombudsman or inspector general or person by whatever name styled. New Zealand was the first non-Nordic country to have an ombudsman. The ombudsman can look at tax complaints, but virtually does not. On the other hand, most of the rights that appear in such instruments around the world appear somewhere or other in New Zealand law or practice. And it's that point that I think makes it broadly consistent with the New Zealand constitutional framework. And so a little bit about this small country far, far away. It is a non-federal, unicameral Westminster system of government. There's no written constitution as higher law. There are written elements to the Constitution. There's the Constitution Act 1986. There's Magna Carta, which is specifically incorporated into New Zealand law. There's the Treaty of Waitangi, which was a treaty forged with the Indigenous people of New Zealand. And all this is held together by constitutional conventions and practice. It works. It is a country of parliamentary supremacy. In fact, it is of even more parliamentary supremacy than the home parliament in Westminster. Every act of the New Zealand Parliament is of equal status with every other. It is a system of responsible government, which means that the executive are members of the House of Representatives, which are obviously duly elected by the people. The executive is the party that can command the confidence of and the supply from the members of the House of Representatives. There is an independent judiciary with a particular role, of course, of interpreting statutes and a role in judicial review of reviewing the public officials and standards, as well as, of course, the protection and development of the common law. I think another point which is particularly of relevance in this context, there is a politically neutral, independent, permanent state service, so that the kinds of things I hear people talking about in the US are totally foreign to me. The New Zealand Bill of Rights Act, in accordance with this, is an ordinary, unentrenched act of the New Zealand Parliament. It could, in theory, be repealed next time Parliament sits. The convention would say it would not. I can't explain to you how that works, but it does. The New Zealand Bill of Rights Act has been described as a constitutional enigma. And to set it, whoops, that went back the wrong way. Oh, technically challenged here. Now, the New Zealand tax system in brief. The Commissioner of Inland Revenue is the chief executive of a government department. She is a member of the Independent Public Service. And she manages a very large department, in New Zealand terms, tiny probably in most of your terms, and assesses tax liabilities. So that is a dual role, which has some inconsistencies within it. New Zealand has a consumption tax, a GST, broad-based, few exceptions at a uniform rate. The other source of income is an income tax, which is global, applying regardless of entity. Includes a few things conventionally thought of as capital. Companies and trustees are taxed at a flat rate. Individuals are taxed at progressive rates. And the world is divided into the very imaginatively named filing and non-filing taxpayers. Most salary and wage earners do not have to file a tax return, or their tax is deducted at source. So it's a relatively straightforward and simple system, and to some degree those issues about vulnerable low-income taxpayers don't particularly arise because their tax is taken from them before they ever see it. There are no deductions against income for salary and wage earners, so you have no argument with the IRD. Basically, tax is taken at the rate that it ought to be taken at, and that's more or less the end of the matter, at least in theory. The Inland Revenue also administers a broad-range family assistance program by way of tax credits. And so I guess what I'm saying is that the Inland Revenue Department in New Zealand deals with people who pay tax and people who receive payments. And I have been thinking a little bit about the fact that the word customer probably applies more appropriately to those who receive payments, but the idea of taxpayers as customers I find rather troublesome. Right, so before I drop my piece of paper here, now into the recognition of taxpayer rights in New Zealand. As I say, it's scattered around various instruments. There is this thing here called the IR's Charter. It's a sort of official piece of Inland Revenue form, an IR 614. It started life as a taxpayer's charter, and somewhere along the line it morphed into being an organisational charter. I've used, in deference to the country in which I'm pleasantly placed, the US Bill of Rights as a kind of template against which to map the New Zealand protection for Bills of Rights. And so you'll see in here all the sorts of things that we would expect to find, and are certainly present in the US bill, and I think probably in very many others. This idea about prompt, professional and courteous service, respecting cultural needs and so on. It's in what I would describe as the aspirational service model. Confidentiality, which appears in there, as we'll see in a moment, is also in the statute. This is not, of course, written in the language or the structure of rights. There is not what I would describe as a constitutional whiff about it. This is a statement of how the Inland Revenue will deal with its customers and indeed the taxpayers that it deals with. And then there is, this looks a bit messy probably, because it is a bit messy. The four headings I've chosen are those four from the US tax bill. You will see that these elements are protected in New Zealand in various instruments. Some in the TAA, which is the Tax Administration Act, some in the New Zealand Bill of Rights Act. And so there is a right to challenge and appeal, there's a right to privacy, there's a right to confidentiality, and a little more amorphously, there's a right to a fair and just tax system. If we look at the protection in the New Zealand Bill of Rights Act, section 27, which is about the right to judicial review of decisions by public authorities. In the respect of taxpayers, that is severely restricted, both in the statute, the Tax Administration Act, and in the judicial application of judicial review in tax cases. And judicial review in tax cases in New Zealand is rather different from the general standard of review that appears in other areas. The right to privacy. The Commissioner of Inland Revenue has an extremely broad right to access all land, buildings and documents. The right that's in the Bill of Rights Act says that all citizens should be free from search and seizure. And it's taken the courts a very long time to try to integrate those two things. The concepts, it's been a long and rather difficult route to get to that point. There is a right to confidentiality, and finally, there is this right to a fair and just tax system. These, I think, are more reflective of taxpayer as citizen rights, but the courts have been rather reluctant to embrace them. And I think to some degree that relates to their conflation of taxpayer as customer and taxpayer as citizen rights. And then we have this rather interesting piece of legislation which sits near the beginning of the Tax Administration Act. Now, I think this provision is something of a phantom. Seems to say a lot and then it scurries away or is chased away by a judiciary that's unkeen to engage with it. It's been held that it doesn't create a series of enforceable rights or obligations. It's been held by the courts to be aspirational. And the integrity of the tax system is more weighted in judicial reasoning to ideas about the system and to taxpayers as a general body rather than to individual taxpayers. So for all its rights language, this, by application and interpretation, has moved somewhat to what I would call the customer rights stage, partly through judicial interpretation. Now, this following slide we can shoot through quickly. Partly I had to do these slides about a month ago. There was proposals out there which have come to nothing. The 2019 Tax Working Group suggested the establishment of a tax advocacy service, and the government has said not in the meantime. The Office of the Ombudsman, it was suggested, should be adequately resourced to carry out functions in relation to tax, and nothing's going to happen unless there's a dramatic increase in complaints leading to a capacity problem, and an idea of designing a simplified dispute system for small taxpayers, and that's going to be considered in the future. So we can shoot straight past that. So, some concluding thoughts. I put that in because I thought something exciting might happen, but it didn't, as is often the way. So, no taxpayer Bill of Rights, but there are scattered protections, and I think that is broadly aligned with New Zealand traditions of protecting rights. And finally, after several years of thinking about this, I'm not especially concerned about that. The focus, I think, in New Zealand is better employed on addressing weaknesses in the scattergram rather than on creating a taxpayer Bill of Rights. I do think that it would be appropriate for us to have some advocate, because at the moment we rely on good inland revenue culture, but relying on good culture is somewhat ephemeral. And I think what would be more helpful is a precise and careful thought about what truly are the nature of taxpayer rights in New Zealand, and indeed might be so bold as to suggest elsewhere. So what sort of rights, what is being protected when we think about taxpayer rights, might inform our thinking about their protection and how they ought to be protected. Thank you. Kia ora.
Thank you very much. We would like to open the floor for the questions, suggestions of the audience. If you may, does anyone want to make a question before I do a bunch of questions I do have here? So, Stjepan, I have this question for you, because I found of both of your presentation, which I enjoyed very much. I found it very, very interesting how to reconcile both the equality test you're proposing in your paper with this three-layered approach, the level of protection, level of certainty and targeting, and source of inequality, with the proportionality test, the standard proportionality test, in a context of constitutional pluralism. Because if I understood you correctly, this three-layered test requires some standardization on what the needs and what the minimum standards of what's equal and what's not are in the context of application. And in Europe, considering the constitutional pluralism you were discussing, it's quite challenging. I would like to hear your thoughts about it.
Yes, well, when I was raising the point of pluralism, I think you can find many examples in Europe where national constitutional courts use the reasoning that was used sometimes in other countries. So, for example, at least in our country, in Croatia, Croatian Constitutional Court sometimes refers to the reasoning of German Constitutional Court. So you can find these sort of linkages. You can find also linkages where they refer to the reasoning which was made, obviously, by the European Court on Human Rights, because this is, as I said, the minimum standard. So you need to observe when the right is basically similar or the same in a national constitution and the ECHR, then national constitutional courts often refer to the previous case law of the European Court in Strasbourg. And also, I think there is also a role to be played here by the court in Luxembourg, by the ECJ, especially in the future when the case law linked with the charter, the European Charter on Fundamental Rights develops. So this is maybe what I was referring to when I said pluralism, and yeah, maybe the future holds some further developments regarding this entrenchment of this dialogue between courts, so to speak, in the proportionality test. That was my idea. Maybe.
If I may add to this, at the beginning I started with this relationship between democracy and equality, and the problems that come from that. Those are the problems in every member state of the European Union, how to balance it. And we don't want to give a concrete answer to how to bring all of that together, but basically just to give a structure to see where the differences are and what the basis for comparability is. For example, we couldn't go that much into detail, but there are different approaches to come to an ability to pay principle in constitutional law. You have countries like Germany, they don't have the ability to pay principle per se in their constitution, at least not as broad as, for example, Croatia or some other countries. But their constitutional courts came to the conclusion, based on the position of the equality principle in their constitution and some other rules in their constitution, to create their own ability to pay principle. And then we come to a similar position in the test, and then we can come to something that is comparable. And that's what we want to do. We might not come with every country in the European Union to the same position, but we at least could group them in a way to find some common principles there.
Out of this inter-court dialogue you are referring, so the basic parameter to identify these common grounds will be the decisions of the courts, right? If I understood correctly. Is there any way of going the other way around? What if, I'm just being provocative here, what if the courts are wrong?
Well, first of all, the constitutional courts are the last instance of their countries, and the states purposefully didn't give up the power to decide what equal treatment is, either to the European Court of Human Rights or the ECJ. For the simple reason, the European Court of Human Rights, as I have shown you, just can decide on discrimination. The ECJ is limited with his equality principle, to European law and to non-discrimination in certain circumstances, for example, based on nationality. So on purpose, the member states didn't give up the power to decide on this part of their sovereignty. So I wouldn't say that their constitutional courts are wrong. They just have different opinions. And we have a plurality of opinions here. We cannot force the states to come together. We have to see where it happens naturally and draw conclusions from that.
So will the practice become the minimum standard, the identification, what the practice in approaching these problems will raise these minimum standards, right? Very well. Please. Yes.
So I have a question. Wait. Thank you. So I have a question for Shelley, and it was interesting to me that one of the last slides that you had on the Tax Administration Act of 1994 sounded to me in many ways like 7803 in that, which Les had up on the screen earlier, the US version of the codified Taxpayer Bill of Rights, in that it exhorted the employees of the revenue agency to behave in particular ways. But unlike the US version, which put the emphasis on respecting taxpayer rights, I found it really interesting that the New Zealand version put the emphasis on behaving in ways that protected the integrity of the tax system. which frankly I also like, but I wondered if you had thoughts on what led to that difference and whether that difference, that is, putting the emphasis on protecting the integrity of the tax system, how that might affect how taxpayer rights are, or an agency behavior is operationalized.
Right, so we've got a day and a half. There's a very long and complex history about that piece of legislation, which I don't propose to bore you to tears with. I think that use of the integrity of the tax system, it also came in the context of giving the New Zealand Commissioner a power of care and management, which is a generalised power to do all sorts of things. And so that specific New Zealand context, which would bore you all to tears, so I won't bother with. I think that placing the integrity of the tax system as a sort of overarching, and the courts have actually grabbed onto that, has meant that those rights have been kind of reduced, I guess one might say. So the rights part hasn't become important. In fact, it's become unimportant at all. Some people have tried to directly enforce those rights and have got absolutely nowhere because the integrity of the tax system trumps them. Now, rights are always trumps, of course. It's always a balancing kind of enterprise. But that expression, integrity of the tax system, has, as I would say, tended to put the system ahead of the individual. And that's how the taxpayer rights have not been particularly protected by that.
Ms. Olson, and then later the gentleman.
So, you know, as I worked on the Taxpayer Bill of Rights, you know, I think that because in the United States, as I'm listening to everyone, you know, our courts have really narrowed any kind of constitutional protections for the tax system. You know, the rights that might apply in other areas of law, they have said, you know, the government, you know, the imperious need to collect the tax trumps basically everything. And we can figure it out later after we've collected this tax. Has led our Congress to pass in our federal system, you know, a lot of statutory protections. And, you know, there are many. And what we did in working on the Taxpayer Bill of Rights in trying to sell it and get a consensus was make a crosswalk between all of those statutory rights and fit them into the 10 rights that we had come up with. And the importance of that, it was twofold. One was, you know, we could show people, you know, this is what the rights, you know, when it was administratively adopted, this will really help taxpayers understand what they do have, because as you say, the scattergram is all, you know, there are rights all over the place. Do you know them? To exercise them. But on the other hand, it really identified the gaps. So there was nothing underneath certain rights in the law, and that leads you to go, well, then what is this promise that we've got? And that's part of the litigation that Les has mentioned and things. But that was a very helpful tool, and I think you started that, but I think I would just encourage you, as you're all thinking about getting a Taxpayer Bill of Rights, to do something along that line.
Gentlemen?
Thanks.
Adrian Sawyer, I'm also a colleague of Shelley. My question is for Shelley. It might be more placed for next year's conference, but whether you've got some thoughts of how in New Zealand might taxpayer rights be moulded into human rights and potentially recognised under the Bill of Rights Act?
Usually when you go and talk at an international conference, you don't have anybody from your country, which is generally a positive. But anyway, Adrian is a good friend of mine. I think there are some sections in the Tax Administration Act that could go. The section that says correctness of assessment is the primary goal. I think that ought to go. And I think somehow having the judges realise that these are human rights and that it's kind of tax exceptionalism, is breaking down that barrier of tax exceptionalism, which I think is partly the role that people like you and I have in New Zealand to articulate that, to get tax out of this funny little box, that it is somehow different And those people who come to court arguing about taxpayer rights are a bunch of cheats. Even if they are, but they've got rights. Even cheats have rights.
Gentlemen.
Hello, good morning, and thank you to the panelists for wonderful presentations. I'd just like to ask something perhaps which might dwell into the realm of something more philosophical. And why do you think that generally the court systems around the world have been reluctant to recognize taxpayer rights as human rights? And secondly, what use are all these various charters and bills of rights if they don't give rise to enforceable remedies such as damages against the state where taxpayer rights are not being properly respected?
Anyone?
I'll take the second of that question, which is the what use question. I think that considering rights just in the context of whether there's a specific legally enforceable remedy is narrow, and I think the possibilities of how rights can inform tax administrators and potentially courts in cases, but administrators is richer than specific. The specific ability to seek a remedy. And again, from the perspective of lower income taxpayers, there oftentimes are difficulties in being able to exercise a remedy even if one is available. So I think one of the possibilities of a broader adoption and explicit recognition of taxpayer rights is systemic change at the front end and influencing how procedures are set and how rules are, and thinking about rules and how they interact with rights. I think that there are possibilities beyond remedies. Would remedies be helpful in certain circumstances? I think so, but I think that it's not all lost.
Can I just, I would agree with that, but I think at some point there needs to be a remedy as a sort of an ultimate discipline. And so the existence of some remedy is the final countdown. But you're right, they have a strong value. And I think that in far as New Zealand's concerned, that IR Charter does guide behaviour. And the New Zealand Department generally behaves very well toward their customers / taxpayers.
Ian Young from the UK. We had a taxpayer charter in 1986, and then when we had a new government in 1992, they were very keen on extending charters to other government departments under the Prime Ministership of John Major. And the two sort of guiding principles that they adopted for those charters was that the charter should explain to the users of the services of the particular administrative department what they could expect from that department, and also they could understand what their remedies were and how they could deal with things which weren't satisfactory as far as they were concerned. So they had some mechanism for complaints against a particular administrative department. The difficulty with tax is it's quite difficult to understand what it is that's on offer from the tax administration and what you're supposed to do as part of that system. So I think it's if you're a public utility supplying electricity and you haven't got electricity, it's been cut off, it's pretty obvious that it's not doing what it should do. In a tax system, it's much more amorphous and it's much more difficult to define what it is that you want. But I think actually having a mechanism whereby you can channel complaints and understand what is not going as well as it should do provides some sort of narrative to determine what is not going as well as it should do. So, and in the UK now, I had a meeting with we have a tax adjudicator. So I met with our current incumbent a couple of weeks ago, and one of the things, and she changed her terms of reference when she was appointed 3 years ago. And one of the things that she now does is more systemically determine what are the sort of complaints that are being made against the tax authority. And also she has a remit to actually get our tax authority to learn from the mistakes. Because one of the great things about complaints and things going wrong is that you can, if you're really good, you can work out what you can do to make sure they don't happen again. And one of the other problems about charters is that they're really talking about behaviours, and it's very difficult to spell out precisely what those behaviours are. You ought to know what it is you're supposed to do and do it. If you have to have a legal remedy and you have to go to the court to enforce your right under the charter, I think you probably missed the point. And it's too laborious and it won't work. You need to instill some mechanism whereby you can ensure that the tax authority does what it should do. And my final point is that actually I think you have to have obligations as well as rights for the taxpayer, because most of us have self-assessment systems where the taxpayer is required to do certain things in order to make the system work. So when I was talking to the United Nations, certainly the Secretary of the United Nations Committee was pretty clear that it would be a very hard sell to the 96 countries in the United Nations if they were told, the administrations were told, that actually what they needed to do was introduce rights for their taxpayers. They want to make sure that the tax system has enough money in it to pay for the public goods. So if you told them you've got to give some rights to your taxpayers, that's not a very attractive proposition. So we were pretty clear that there are obligations as well as rights. So when the International Chamber of Commerce published a charter with some help from me last June, July, they introduced obligations into their charter as well as rights. I just think it's a two-way street. You've got to make the system work. You've got the tax authority has to behave in an appropriate way, has to understand what it's required to do. But equally, the taxpayer has to have a system which is easy to comply with. But equally, they have some obligations to pay tax on time, to sort of fill in their tax returns as required, various other things which are necessary for the good working of tax systems.
Are there any final remarks from the panelists? Well, I think... Sorry.
I just would like to make some strong points with regards to the real purpose of this paper, because it was not given so much clarifications, because it was the last part of the presentation of my boss, Attorney Dasil. You might wonder, with all those loads of laws that we have, he has enumerated from the Constitution to different laws that we have passed and updated recently. Why do we still have to pass a taxpayer Bill of Rights in the first place? Precisely because of these numerous laws, it has become very difficult for taxpayers and for lawyers and for tax administrators to really compress these rights and privileges into a single document, as a single reference, to speed up the resolution of disputes, the resolution of the challenges about the computations. So that's why in this proposal, we are planning to extract all these provisions from voluminous pages of statutes and organize this into a single statute, just like what the US has made, and other countries, like in Great Britain. We visited Great Britain in 2017 to study their system. And so for this reason, we find it beneficial for the taxpayers particularly to have this condensed and compiled in a really easy to read, easy to access, and easy to understand languages. And I would like to add that all of this would not materialize to the fullest if we will not create the Office of the National Taxpayer Advocate. We recognize its essence in this whole exercise, because without this office, nobody would have that focus, the focal effort or initiative to really look at the concerns of the taxpayers. With this office, we are confident that, like in the United States, all of the problems the concerns of taxpayers as well as the concerns of the tax administrators and practitioners would easily be resolved. So, and you would, and finally, you would wonder, we have the initiative to legislate a taxpayer bill of rights in the Philippines started way back in 2013, and 6 years after, no laws has been passed. Why? Because the level of understanding, the level of commitment of legislators are yet to be enhanced. So it is translated to less motivation to really push for the legislation of this effort. That is why our office is being at the forefront of this Committee on Ways and Means. We believe that with our effort and our commitment to push for this, to inspire our legislators, and with the help of these resources that we have, and particularly the experiences that we gain, the insights that we gain from conferences like this one and in future conferences, hopefully, in due time, in so short a time, we would finally able to pass this very important legislation. Thank you.
Okay, so I think it's very important for the conference every time to start with a panel that sort of creates a baseline, for where we are in different countries working on rights, sort of the status of rights, and it may take a different theme with each conference, and I really want to thank each and every one of you, and our moderator, our esteemed moderator, for this wonderful panel. I'm going to take my convener's privilege and just mention one thing, because you were talking about taxpayer obligations. In the United States, again, when we were working on the TBOR, I had originally proposed taxpayer rights and taxpayer obligations along the lines that OECD had suggested in some of their studies. And we focus grouped the rights and the obligations that we had designed with taxpayers and practitioners throughout the country, all in various sites throughout the country. And unanimously, people came back and said they were absolutely insulted that we had laid out taxpayer obligations. They're like, of course we have the right to be honest. Of course we have we have the obligation to be honest. Of course we have the obligation to pay our tax. And so we still made that recommendation, but the commissioner, when seeing the results of the focus group, because the IRS was adopting the Taxpayer Bill of Rights as like a PR response to a very big scandal that was occurring at the same time. They didn't want to tick the taxpayers off anymore, so they just dropped the obligations from the Taxpayer Bill of Rights. And that's how that happened.